In 2011, Zambia took a crucial step towards addressing the pervasive issue of gender-based violence by enacting the Anti-Gender-Based Violence Act. This act was designed to combat systematic violence stemming from gender norms and roles and providing victims with protection, support, and justice. This presentation explores the journey of the implementation of the Anti-Gender-Based Violence Act, its significance, the study conducted to enhance its effectiveness, and the resulting recommendations for legislative improvement. Gender-based violence arises from socially constructed roles leading to inequalities and abuse. In Zambia, like many other places, people suffer abuse due to their gender, impacting their lives and well-being. The Anti-Gender-Based Violence Act, passed in 2011, aimed to tackle this issue head-on. The Anti-Gender-Based Violence Act had a profound impact on Zambia's efforts to combat GBV. It established mechanisms to safeguard victims and created the Anti-Gender-Based Violence Committee and Fund. This paved the way for the creation of the GBV Fast-Track Court, specifically designed to handle GBV cases more efficiently. Despite the enactment of the anti-gender-based violence, statistics reveal that gender-based violence cases continue to rise in Zambia. A performance audit was conducted by the Auditor General on the management and disposal of gender-based violence cases in Zambia from 2017 to 2022. This period revealed that despite reported cases of GBV, prosecution remained low. Child victims in particular faced difficulties due to a lack of child-friendly courts, often resulting in case withdrawals. This study sought to identify gaps and propose solutions to strengthen the Anti-Gender-Based Violence Act. To achieve the objectives of the review process, the Commission employed the qualitative research methods. This included desk reviews, consultations with stakeholders, drafting meetings, and validation sessions. The desk review process involved analyzing primary and secondary sources of data such as domestic laws, international instruments, and human rights standards. This process aimed to uncover gaps and challenges within the Anti-Gender-Based Violence Act. Key stakeholders including women and law in Southern Africa, the National Prosecution Authority, the judiciary, cooperating partners, and the civil society, to mention a few, collaborated in the desk review. An issues paper was developed shedding light on the shortcomings in the Act's provisions, relevant policies, and administrative structures. This laid the foundation for further research and discussion. Some of the challenges stakeholders identified in the fight against GBV and implementation of AGBV Act related to the definitions of the terms abuse, harassment, care institution, child, gender, emotional, verbal and psychological abuse as defined in the AGBV Act should be linked to an offense in the Penal Code. The actions that amount to physical, mental, social, and economic abuse such as stalking are not provided in the Penal Code. However, other acts such as making the victim feel sad or depressed are civil in nature. Further, the term physical abuse occurs twice in the same definition, and in this regard, the provision should be harmonized. Additionally, the discouraging nature of cumbersome processes involving tasks like obtaining medical and police reports could be mitigated through the establishment of a convenient one-stop center that ensures easy accessibility. Also, the victim's economic dependence on their perpetrators creates a strong discouragement for them to report those responsible, for they are their primary breadwinners. This financial reliance often results in a reluctance to come forward as the victims fear potential consequences that could further jeopardize their already precarious economic situation. Zambia's commitment to combating GBV extended beyond its borders. The country is a signatory to various international and regional instruments addressing gender-based violence. These agreements provided valuable perspectives and benchmarks for enhancing the Anti-Gender-Based Violence Act. The experiences of other jurisdictions were a key source of the best practice in the review process. Comparative legislation from countries like Zimbabwe, Kenya, and Namibia was examined. This gave an insight on various approaches to tackling GBV and provided a means for creating evidence-based recommendations. The Commission made the following specific findings based on the submissions received during the stakeholder consultative meetings and the findings from the desk review. Some of the findings were that 1. In Section 157 of the Penal Code, harmful cultural or customary practices are only penalized when they result in injury. The Children's Code Act, in addressing harmful cultural practices in Section 18, does not limit penalties to only when injury arises, but makes them applicable where physical dignity and psychological development are compromised. 2. The AGBV Act outlines abuse arising from customary rights or practices, for example, forced virginity testing and female genital mutilation, which abuses are not adequately addressed under Section 157 of the Penal Code Act. 3. The Immigration Department and Zambia Correctional Service play an important role in the fight against GBV in regard to vulnerable migrants and women and children in conflict with the law. However, the two institutions do not sit on the Anti-Gender-Based Violence Committee and therefore do not participate in important decision-making processes concerning the aforementioned groupings of people under their charge. 4. The Domestic Violence Act of Zimbabwe criminalizes certain acts of GBV and provides recourse for acts of GBV that are civil remedies. And 5. In the SADC Model Law, the Domestic Violence Act of Zimbabwe, aggravating circumstances are taken into consideration in the sentencing of perpetrators of GBV. Based on its findings, the Commission made some of the following recommendations. 1. Amend Section 157 of the Penal Code to extend application of penalties to instances where no injury has arisen from the harmful cultural or customary practices as long as all other elements of the offense are satisfied. 2. Section 157 of the Penal Code be expanded to include abuse arising from customary rights or practices, for example, forced virginity testing and female genital mutilation as provided in the AGBV Act, and further that it may be reconciled with Section 18 of the Children's Code Act. 3. The composition of the AGBV committee established in the AGBV Act should be revised to include representation from the Immigration Department and Zambia Correctional Service, respectively. 4. Criminal offences involving GBV in the Penal Code should be enhanced to correspond to acts of GBV provided in AGBV Act. However, acts of gender-based violence that are not criminal in nature must be dealt with through civil suits procedure as provided for in the AGBV Act. 5. Sentencing guidelines should be developed to ensure that, among other considerations, acts of gender-based violence that are aggravating in nature attract a heavier sentence. And 6. Acts of gender-based violence that amount to emotional, verbal, physical abuse should be pursued by way of a complaint in civil procedure. In conclusion, the journey of the enactment and implementation of Zambia's Anti-Gender-Based Violence Act has been marked by significant strides, challenges, and a commitment to improvement. The study's outcomes and recommendations provide a roadmap for enhancing the legal framework and addressing the gender-based violence more effectively. The Commission's gratitude goes to all stakeholders who participated in this process, showcasing Zambia's collective dedication to a safer and more just society.